And
Awesome.
oh, sorry, did not mean to jump in. I just before I forget, I want to say if you guys have any questions, just because I know a lot of this stuff is very dense, it takes 5, 10 to repetition, and you all are here, and I appreciate that. So I was just going to say, if any of you have any questions, we could certainly just kind of you could put them in the chat or anything like that, and certainly I'll make sure and set aside some time to get to any of those.
Awesome. Yeah, it's a good point. I can monitor the chat as well.
Okay.
So yeah, for questions in there.
All
Cool.
right.
Well, yeah, we will get started. So yeah, this is generally our caregiver support group.
Yeah.
Pretty standard once a month, like-minded caregivers just getting together. As I kind of mentioned to you, Will, came up in the past that a lot of our caregivers were interested in kind of hearing from guest speakers and then specifically on special needs trusts, ABLE accounts, all those things you kind of touched on. So yeah, thanks for joining us. We really appreciate it. I know there was a lot of people, like I said, at least 10 who emailed me who are really interested, couldn't make it today. So we'll definitely send your presentation, the recording of this out to everyone so everyone has it.
All
With
right.
that, I will turn it over to you.
All right. Well, before I pull up the presentation, I'll give everybody just some kind of the quick elevator pitch of who I am and what I do. So my name is Will Beyers, and I am one half of Beyers Law, and so we are basically an estate planning and special needs planning law firm, and we are located in Northern Colorado. Our head office, lead office, I guess, kind of our hub, if you will, is in Loveland. But we serve clients all over the state, and certainly quite a few other states as well. And so, really the focus when I say that we just do estate planning, special needs planning. That's really all that we do. My dad has about 25 years of experience in the Medicaid sphere, and that very naturally led itself well to getting into the special needs community and being able to provide something in that regard. And truthfully, I've just kind of taken the reins, and I would say that if 90% of my work could be special needs planning, that would be pretty darn good for me, because it's a complicated sphere. As a relatively new parent, I know that there's a lot of times it's a very emotion filled experience, and so I think really our job and what we endeavor to do in these cases is really just to make sure that our clients and their families, that they know all the options that are available. And it can feel very daunting at times. I can tell you that I'm a specialist in this, and I feel overwhelmed at times just with how things move, or how quickly things move with Medicaid and special needs laws and all of the all the other things that go along with it. But yeah, that's kind of the crux of what we do. And with that, I will pull up the presentation here. And okay, let's get this guy going here. All right. Okie dokie. So basically, what I told Brian when I emailed him is this was actually a little bit longer presentation that I did for ARC just recently, and so the one of the first portions that we talk about here is understanding public benefits. And just in the interest of time, it'll be on the slide that I shared with Brian, if you guys have any interest. But anytime you're talking about planning for a loved one with special needs, certainly having at least a foundational understanding of the differing benefits, and what they provide, what their restrictions, their limitations, their requirements are. That is, that's an important thing to kind of slowly acclimate yourself to. And I'm probably preaching to the choir here, because I would imagine you guys are far more versed in this sphere than many people. But really, why would we engage in estate planning for a special needs family? I mean, I think the core component is that we want to provide as many opportunities, we want to provide as much quality of life as we possibly can for the family and for the individual. And I tell people that, my job when I'm doing estate planning or special needs planning is that I want to put all of the individuals in the best position to succeed. And that's really a lifelong process. But, again, I think kind of the core of what we'll be talking about with special needs trusts is we want to supplement. And so if you hear me use kind of interchangeably the term supplemental needs trust or special needs trust, they're both referring to the same thing, but we've actually kind of started shifting to referring to them as supplemental needs trust, because I find that to be more indicative of really what their exact purpose is, because we want to, we really want to provide for everybody in the family in the most effective fashion. And if there are special needs involved, then there's just a little bit more, a few more hoops that we want to jump through to make sure that, number one, we can maintain any benefits that they're currently receiving, or at least leave that option on the table for the future. And also, if that's part of the estate plan and you say, hey, I wanted to go to my kids equally, and you have one special needs child, it used to be kind of this horrible practice of people would just disinherit their special needs loved ones because of the concern of losing the benefits. But the reality of it is there are a lot of things that we can do to provide for someone in that situation. And I look at it as we just want to have as many options on the table as humanly possible when the people who are likely their biggest advocates, whether that's mom, dad, a sibling, when they're no longer around anymore. And so kind of moving into the, of course, we'll jump past this stuff. So understanding special needs trust. So to start, really what a trust is it is basically an agreement between the trust maker, the trustee, and the beneficiary. So in a supplemental needs trust, let's say I have a special needs son named Adam. So if I'm setting up a special needs trust on his behalf, then Adam in this scenario is going to be the beneficiary. He's really the individual that we're setting up the trust to provide for, to benefit for. And the trust maker or the trust maker is usually going to be mom and dad or a family member who want to provide for them. And then oftentimes they will be the trustee as well. And so the trustee is really, they're kind of the one managing, overseeing the trust until, usually until they're gone, because that's usually when that special needs trust is going to be funded. That's kind of an aside, and I'm trying not to go into the weeds on this a little bit, but just kind of as a general idea, usually what we suggest is if we're setting up a special needs trust for an individual, my personal preference, our office's personal preference is actually not to fund it until the parents, the people establishing the trust, have passed away. And I'll be happy to flesh that idea out a little bit later, but it mostly has to do with Medicaid is they're very wonky about trusts, and I like to just avoid any confusion when it's not necessary and it's not funded yet. So there are two types of supplemental needs trusts that Medicaid recognizes and that are in common use. So there is a self-settled, a first-party trust, which is typically the result of, the most common example that I see where there's a first-party special needs trust in play is usually if there's been some sort of medical malpractice. So somebody develops a disability due to an error made by the hospital, and the child then in that case, they're essentially the payee in any sort of lawsuit. I've seen that happen quite a few times. And so in that case, the money is directly attributed to the special needs individual. And so because of the source of the money, because it's in their name, because they're legally entitled to it, that is where they're required to go the first party special needs trust route. So kind of the key distinction there is third party, it's going to be set up and funded. The money's coming from somebody else on their behalf. And a first party trust, they're receiving the money, whether, grandma just left them, left them a sizable inheritance, and she didn't think to, look over the planning involved. But anything that's going directly to the individual, that's where, it has to be a first party special needs trust, because it's treated as legally their property. But the third party trust, where mom, dad, uncle, aunt, they're setting it up on behalf of a special needs individual, that's when it's called a third party trust. And a third party trust is wonderful, and it's really the preferred option for many reasons. The biggest reason, though, is that it allows, when it's drafted correctly, a third party trust that leaves money to a special needs individual, it will not be considered an available resource for Medicaid, and it has to be used for the benefit of the individual named. So, and then the final kind of key distinction there as well is that any remaining assets in a third-party special needs trust, once the special needs beneficiary has passed away, if there's any property remaining, the people, or the trust makers in this case, mom and dad, they can specify where any remaining funds go. They do not need to be used to pay back Medicaid. And so for somebody who's been on, government benefits for a very long time and has had, a sizable amount of money paid out on their behalf, that's really a great way to, set them up so that they can have that supplemental care and that money available to, to provide for them while they're alive. But then you also have the added benefit of any remaining assets, they can be designated to go to grandkids or their siblings or anybody else that you would see fit. So there are a couple different, and I guess kind of going down the, there's an additional type of supplemental needs trust outside of the first and third party. Oftentimes it's a third party pooled trust, but a pooled trust I'm not sure if any of you are familiar with the Colorado Fund for People with Disabilities. But basically what a pooled trust is it's usually a charitable organization such as CFPD, where their sole job is to act as the trustee for special needs individuals. And so it's a good option in many cases. One of the biggest ones is that there doesn't have to be any sort of Medicaid review period. They don't even have to look at the trust if CFPD is going to be administering it, because they're so familiar with them that they just kind of say, hey, you know what, we're going to trust that everything is good to go. We don't have to review the trust the same way that we normally would. But with that, anytime it's not a family member administering it, there is that risk of not getting the same level of care that perhaps a sister or a family member would be providing. But again, it can be a great option as far as somebody who doesn't have a successor trustee, doesn't have a brother or a sister or a family member who they would trust to administer a trust after they're gone. And so the distribution standards. So the distribution standards of a trust basically are the guidelines of what the trust funds can be utilized for. So mom and dad leave $500,000 in a special needs trust. The parameters of the trust, the distribution standards being part of that, those are going to dictate what exactly that money can be used for. And this is really where the devil is in the details as far as making sure that Medicaid is not going to treat it as an available asset. But there's been a lot of shift over the past 2 decades in the special needs planning sphere. And, without boring you all to tears, basically the trust parameters that we prefer, the distribution standards that we prefer, are completely discretionary. And so really what that means is that we are giving the trustee of the special needs trust, if that's that's the special needs individual's brother, for example, we're going to give them very broad latitude to essentially adapt to the circumstances and make sure that whatever, perfect example would be I've seen a lot of trusts over the years that mandate there could be $1 million in the special needs trust, but it mandates that that money cannot be used if it's going to jeopardize any sort of benefits that they're receiving. Well, in certain situations, that may not make sense, and there may be a better quality of life available while giving up some benefits. For example, if someone is receiving Section 8 housing, well, maybe there's a better living situation available for them that's going to cost a little money out of pocket. If it jeopardizes, it's true that, you always want to be wary of jeopardizing any benefits that are being received, but really we approach it from the standpoint of we don't know what what things are going to look like when this trust actually becomes effective and is there to take care of the individual. And so I like to make sure that we have a very trustworthy trustee who you feel confident that they're really going to look at it through the lens of the special needs individual and say, hey, we're going to do, we're certainly going to keep any benefits on the table. But if we have these funds available, it's nice to have these options and be able to, really assess what is going to be in the special needs individual's best interests. And so that's kind of, I guess the distribution parameters. And, I understand how sometimes this can probably feel like Latin to the layperson, but really the key component to all of this, I think, is that a special needs trust, it has to be drafted in a manner that Medicaid is going to deem it as a non-available asset. And so all these things like discretionary, the distribution standards, et cetera, that all plays a very important point or a very crucial role in ensuring that if you're leaving money to this special needs trust, that it's not going to be treated as an available asset for Medicaid purposes. And therefore, it's not going to cut off any of the benefits that they're currently receiving or that they could be eligible for in the future. And one of the key components of a discretionary special needs trust is that the special needs individual, the beneficiary, they cannot have direct access to the money. So that means they can't be, the trustee cannot be transferring $5,000 to them or, just handing them cash out of the ATM. It more kind of works in, a collaborative situation where a good trustee, they're going to be checking in with the individual regularly. And if the individual needs a new computer or they need new furniture for wherever it is they're leaving, or they need a new vehicle to, increase their mobility and to make things easier. Those are all situations where rather than handing over money to the beneficiary, what a good trustee is going to do is they're going to say, okay, this is what you need. I'm going to go out and purchase it on your behalf. And that's how we're going to, stay above board with Medicaid and make sure that we're not putting them at risk of losing any benefits. So the trustee of a special needs trust, they have a lot of responsibilities. And so I sit across from a lot of families who are sitting down with me and they're saying, okay, we've got 4 kids and we have, our youngest son, he has Down syndrome. And so we need to talk about what things are going to look like when mom and dad are gone and how we're going to provide for that child and for the other children, and how we're going to make sure that we've got a trusted individual in that trustee role, because they've got a lot of responsibility. And so if I was appointed trustee and I had a special needs sibling, I'm going to need to make sure that any of the assets that in the special needs trust, that they are being effectively and the prudent investor standard is kind of what the legal realm uses. And that's basically saying, all right, if mom and dad designated $500,000 to go into your brother's special needs trust, you better not be just stuffing it under the mattress. You need to ensure that you are being proactive with it, that you are doing everything you can to make sure it's going to be there and, hopefully grow over the years so that it can continue to supplement the beneficiary's lifestyle for as long as manageable. And so, all of that's going to entail keeping very detailed financial records, checking in regularly with the beneficiary, filing taxes, hiring care managers, anything that is going to, I kind of look at it as, if you had a company card, you're going to have to answer for the purchases that you're making. And so you just want to make sure that you're being responsible and that you're looking at it from the vantage point of, you have a fiduciary obligation as a trustee to make sure that the assets that were left for the individual are being used in the most effective fashion. So I could spend an entire day discussing what I think are the important characteristics of a good special needs trustee. And truthfully, I have to have a lot of hard conversations with parents where they have an instinct perhaps to just assume that, the oldest child who's, I don't know, maybe 24, recently married, that they're going to, that they're just going to take this on and do a good job with it. And so I think part of our job in counseling families as we're discussing these options is making sure that we're giving them an adequate view of everything that it entails. And it's certainly not an insurmountable task by any stretch, but one of the things that I do in my special needs trusts is I make it very clear that if it's a family member who's acting as the trustee, I'm going to give them full authority to hire accountants, to hire financial professionals, to hire caregivers, anybody who could make better use of the funds, anybody who can help them out, anybody who can, put it really just the same as you would hire professionals if you've got some complex business. We want to make sure that they have that they're not having to go out of pocket to ensure that they're doing a good job administering this trust. And so creating an effective plan for your child or your loved one. So what kind of plans could you make? Well, number one, you could do nothing. That's something that I see a lot of people do, sadly. You could leave money directly to the disabled child. You could disinherit the disabled child, leave money to a future caregiver, or establish a third party or a first party S&T for the disabled child. And obviously, I'm a bit biased because I approach estate planning from the standpoint of I don't know when I'm going to die. I don't know when my clients are going to die. I don't know how things are going to shake out. So I think that the best thing that we can possibly do with the knowledge that we have is ensuring that we have a lot of options on the table and a lot of different ways to adapt and provide for everybody who's involved. And so, I think kind of the starting point that I often discuss with people in the situation is, it can seem incredibly overwhelming. I'm not expecting anybody to go out right away and say, hey, I'm gonna get a special needs trust established tomorrow. I think it's really a learning process, because what may be right for you could be completely different for your neighbor. And I've had plenty of special needs families with similar circumstances who have arrived at different conclusions, and that's completely okay. I mean, really, anybody who talks in absolutes, particularly attorneys, I'm very wary of. And so I think the most important thing is, kind of first finding somebody who you trust. And one of the things that I absolutely love about the special needs community is that I have yet to meet an individual from any sort of involved institution who has not been willing to open up the door and answer questions or point people in the right direction. And so I think, kind of the first step in this planning sphere is finding, putting together a team, really. And so a lot of people, they start out with somebody like a Foothills Gateway, they have caregivers, they have different institutions that they work with to ensure, the adequate benefits for the individual. And then I think once you get into the estate planning sphere, ask your friends if you're in Colorado Springs, or you're in Denver or whatever, and you don't know anybody who's worked with kind of a special needs planning specialist, please shoot me an email. I would be more than happy to give you references of people that I have worked with. It's a very tight knit group, and I usually tell people, hey, I'm going to give you the names of people that I would trust to do the planning for my family if I was in that scenario, because I've seen a lot of their work. And so, certainly I think kind of finding somebody that you're comfortable with, and, just starting to think through if you passed away tomorrow, how would you want things to proceed? Where would you want things to go? Would you want, I have many clients who they have a special needs child living in their primary residence with them. That's something that you can address in estate planning documents, and that you should start thinking about and talking about, because prior to just moving to the proactive side of the law, I did probate litigation and some trust litigation, and I can tell you that without fail, problems arise when people aren't on the same page. That is really where problems always start. And so I think, to the extent humanly possible, even as difficult as these conversations can be, I can assure you that having the trusted parties, having the family members, the people who are involved, the people who you intend to be involved, just, periodically kind of having these conversations and slowly kind of working through how you would want things to play out. That is, that's a huge first step. And I think that's really kind of what can get you to, to a full bore, comprehensive, special needs estate plan. At the end of the day, is it really just kind of starts with thinking through, all right, if we were gone and we have this loved one that we want to provide for, how are things going to look? Who's going to be involved? How much would we want to leave behind? How would we want to structure it? And so one of the other things that I am a big proponent of, and this does not require, I do this in tandem with special needs trusts all the time, but it's certainly, you could do it without any estate plan, really, is creating a memorandum of intent. Every single special needs individual, every single individual period is different. And so I think that if I was stepping into the role of a trustee, let's say I'm a sibling, and obviously, I'm close with my brother, but maybe I live out of state and I don't see him every day. I think that the more you can kind of start putting down onto paper, hey, this is their likes, their dislikes. This is who they are, what their quirks are, what they enjoy doing. All these things are very, very helpful when somebody is going to be stepping into the role that a primary caregiver is in right now. And so, I think that's really kind of the crux of today is that doing this kind of planning, it is a process. And I think that the biggest step forward that anybody can take is just by starting to run through that mentally and saying, okay, if mom and dad are gone, or if you're the primary caregiver for a sibling, if you were in a car wreck tomorrow, what would things look like? How would you want them to look? Who would you want involved? Because the more that you can kind of start fleshing out those questions, the more that you can start really, really kind of grappling with the difficult decisions of, to give you an example, the hardest decision for my wife and I, when we were doing our own estate plan, was if something happened to both of us, where are our kids going to live? Who would we want being the guardians for them? And so, it's really kind of the same thought process when you're doing special needs planning, is what would the living situation look like? What's the team going to be? And so, really just kind of walking through those scenarios and, sitting down with the trusted individuals, and I think the more that you can start to have these conversations and be working through these ideas, the more clarity you're going to start having. And that's really where once you have an idea of what you're looking for, what you want that transition in life to look like, you're going to make it very easy for the attorney, because those are the kind of questions that we spend a lot of our consultation discussing is, who are the trusted parties? What do you want the inheritances to look like? What are your concerns, your goals, etc.? And so again, expand a little bit on the memorandum of intent and what that can entail. But another good exercise certainly is to kind of take a current accounting of the special needs individuals' assets. Are they receiving SSI, SSDI, Social Security? Are there any anticipated inheritances? Are they working? All of these things can kind of start to give you a little bit of a picture if all of a sudden, mom and dad or anybody else who's helping, if all of a sudden they were gone, because, really that is where you can really kind of start dialing in what would be an appropriate setup for when you're no longer around. And that kind of helps direct what your estate plan would look like as far as, how much you're designating or in what fashion you're designating it. And so again, I think that when it comes to effective, proactive special needs planning, I'm a firm believer that the third party special needs trust is king, because it gives you the highest level of control. And I often describe it as, for parents of special needs kids, mom and dad are going to know that child better than anybody else in the world. Now, siblings certainly are close, but I want the person dictating the plan. I want to have mom and dad. I want those loved ones' input while they're still here, so that we can really lay it out in such a fashion that it is going to be the most comprehensive and adaptable plan humanly possible when the special needs individuals, their biggest advocates in life, are no longer around. That's really what we're planning for, is, when mom and dad are no longer here to help out, what's it going to look like? And the more that you can kind of start fleshing out those particulars and saying, hey, here are all the things that maybe sibling would have no idea goes on with the day-to-day. That's where you can really drill down pretty much everything in a third party special needs trust, and almost just kind of set up a life plan, if you will, where you can determine how much, what assets are going to go into that special needs trust, how they're going to be used. You can preserve any benefits that they have or that they may be eligible for in the future. And you can determine exactly who's involved and who's not involved. And that's where I really take a lot of comfort in just knowing that, we're doing the best job possible to provide for a difficult situation. And, certainly one of the other questions that I've been getting a lot recently is that, how much, let's say there are 3 kids and one of them is special needs. I often get families sitting there kind of struggling to come up with, okay, well, perfect world, we'd be doing a third, but that may not be appropriate. And even if there are no special needs involved, that still may not be appropriate. That's certainly for mom and dad to decide. And there was a tendency in the past to cut out or leave a minimal amount to special needs individuals, because I think there was just a misguided perception of, well, there's government benefits to take care of them. Well, anybody who's had any exposure to Medicaid and that realm knows that that's not exactly how it works. And there are a lot of gaps that need to be filled at times. And so, truthfully, I'm of the opinion that I would much rather overfund a third party special needs trust and perhaps give a larger portion to the special needs individual, particularly with a special needs trust or a third party special needs trust, because then if there's anything left over, if you did overcompensate, well, then that money can go to the other siblings or the other family members or whoever else you would want. And so I think it's kind of the best approach, but again, that's simply my opinion. Let's see, we've got a couple questions here.
Yes, we did have a question that just came in, a really good one from Renee. So Support Inc., we're a residential agency that kind of works with individuals and families. She's asking, which I'm not sure about, can a residential agency be a trustee? And then also, if there's not anybody available to be the trustee, what kind of happens in that situation?
Sure. I would, Brian, I would have you take that back to the powers that be. I think so. For example, I've never seen I can't say that I have come across an agency serving in that trustee role, and I think I would have to imagine that the primary reason would possibly be that there could be some sort of conflict of interest. Typically what I tend to utilize is, and I apologize to the individuals who are not in the Northern Colorado area, but I have, over the years, I have seen different institutions, different trust companies. So, a good example would be I've worked a lot with First National Bank's trust department in the administration of special needs trusts. And I know that they're capable of administering special needs trusts. And so a lot of times, if there's not an agency or a family member who would be available to serve, I think it's certainly a great starting point to talk to your bank and see if they have a trust company. Adams Bank, they're kind of spreading out over Colorado. They're based out of Nebraska, where I went to law school. But I'll tell you what, I was absolutely blown away at just how knowledgeable their trust director was when it came to special needs trusts. I mean, we went on, and I was, I don't expect too much with just most trust companies. They want to do the traditional easygoing trusts. They're not really familiar with special needs trust administration, but I think kind of some of the smaller to middle size trust departments, and again, they're almost always attached to banks. I think it's a great spot if you are a great starting point if you have a good relationship with your bank to bring it up to them and say, hey, can you guys administer trust? Because usually the first thing that they're going to do is they're going to put you in touch with somebody, and that is where you can ask all the questions that are important to you. And so Adams Bank, for example, I kind of grilled. I took a client of mine who she had a special needs son who's going to need a lot of care, and we were setting up a special needs trust for him. She didn't have a trustee who she could utilize, and so we went in together, and we were being interviewed by one of the trust officers for Adams Bank, and we were doing the interviewing. And man, the questions and the layouts that they proposed. I mean, one of the things that really stuck out to me, and that I would say certainly to keep in mind when you're exploring third party options would be, I loved the fact that they said, hey, you know what, even if we're just a potential trustee down the road, even if you don't have bank accounts with us, we want you to come in once a year and give us an update on your son. Tell us what he's into, what his who he is as a person, because if we're getting put into that trustee role eventually, and our job is to administer the trust for your special needs son, the better we know him, the better we know you, the better we're going to be able to do our job and provide for him. And so I think a lot of it is, there are a lot of trust companies who are capable of administering them, but I really think it comes down to the same thing you would look for in a caregiver or in an agency. Is that personal touch there? And do you feel like there's somebody that you could trust with that financial component if all of a sudden you're not around? Sorry. Okay. So what should your child do? So this, this kind of steps foot into another avenue that I would imagine a lot of you may have some exposure to, but guardianships and conservatorships. So I handle a lot of guardianships and conservatorships, and 90% of the time it's for a family who they have a special needs child who's turning 18. One thing that I like to relay to any special, anybody in the special needs sphere is that if you're in that scenario, it's very likely that at some point during the talks, during the educations, during the involvement you've had over the years, that you've probably heard somebody kind of insinuate, well, you're going to have a guardianship for the special needs individual. As anybody who has had any exposure to autism can attest, one person with autism does not indicate what another person with autism is like. And so it really is, and I say this just because I've had to talk to a lot of people over the years who they come in and they're ready to get a guardianship in place. And I kind of ask them a little bit about the individual, and we start having these talks. And then I realized pretty quickly on, I go, hey, there's less restricted means that we can utilize here. And if the goal is just making sure that mom and dad are able to be involved in decision making or setting up doctor's appointments or things like that, you don't necessarily have to go that court involved route. There are a lot of different options. And if somebody is high functioning, for example, a lot of times we can just do powers of attorney, for them. It really kind of goes back to we want involved decision making. The court views protective proceedings, so guardianships and conservatorships, those are matters of last resort. And so I think, outside of just, that ethically, I think we really have to take everything on a case by case basis. And so I guess where I'm going with that is that to the extent that you can have the individual involved in these planning talks, whether for them or for the family, I think that's a great option. And so I always tell people, don't assume anything. Certainly ask questions, because man, if there were ever a sphere where there is not a one size fits all solution, it is certainly the special needs community. And so, we talked a little bit about, first party trusts. So if your child has assets, let's go back to that. You have a high functioning child, they work 10, 15 hours a week, and they're getting some income of their own. Well, if they're on Medicaid, then you've probably heard that they cannot go over that $2,000 limit in their bank account. Well, that is where ABLE accounts come in, and boy, am I a firm proponent, a big fan of ABLE accounts, because I really think that they're kind of like a diet supplemental needs trust. So the theory behind ABLE accounts is that any disabled individual, and they actually I see on my slide, it says the onset of disability must be before age 26. I believe they actually passed legislation at the beginning of the year that bumped that up to, I want to say 62. But either way, for a disabled individual, in 95% of the cases, what they can do, or what mom and dad or the involved, the rep payee or whoever it is who's involved in their lives, they can establish an ABLE account. And it's basically just like going on and setting up a bank account for yourself, where now if an individual is making, if they're creeping up past that $2,000 amount through no fault of their own, then you can utilize this ABLE account to plug away any overages. If grandma wants to give them, $5,000, you can plug that into an ABLE account. And so as of 2023, if you set up an ABLE account for a special needs individual, they can put $17,000 per year into that account. And so basically, I have families who they set up an ABLE account, and they had a son who was really working, he was working probably 30 hours a week during the summer. And so they were getting pretty concerned about, him jeopardizing his Medicaid benefits. But because they established an ABLE account, they were able to take any overages over that $2,000, plug them into this ABLE account, and then if you can get debit cards for the individual, you can get checkbooks, you can still have oversight, but the great thing is that they can pretty much use it for anything. I mean, if you're buying, if somebody needs a new computer, that's a great use of those ABLE account funds instead of mom and dad having to go out of pocket. And so really, the contributions, they grow tax free. And, again, it's one more avenue to ensure that there are options available for, people who are bumping up against that resource maximum. And so, yeah, I mean, and one of the biggest recent changes. So it used to be that the downside with an ABLE account was, at the end of the day, if something happened to the individual and they were plugging a lot of, they were putting $17,000 a year into that account, and all of a sudden they pass away and there's $80,000 in that account, that it used to be required that it would pay back Medicaid first. They were kind of the initial payee. But somebody, I believe it was through ARC, but some attorney who I'd love to meet and shake his hand, he basically the ABLE accounts were modeled off of the 529 accounts for Colorado, and or kind of the 529 federal plans. And 529 accounts, if I set one up on behalf of my son and there's $100,000 in there and he doesn't use it, we can designate where that goes. And so the attorney, the special needs attorney, basically said, wait. If this is modeled off of these 529 plans, why are we penalizing special needs families for them utilizing these accounts when there's no, correlating penalty for these 529s? And so as of 2023, there is no that Medicaid payback for any remaining funds in an ABLE account, it no longer exists. So if somebody sets up an ABLE account and they're plugging away $10,000 per year in there, that's where you can list a family member, a beneficiary. You now have the authority to direct where any leftover funds would go. And so that was, that was a great win that I was very happy to see, because once again, it's a great option for a lot of individuals. And certainly I think the best example of just how great these can be, I have had many people come into my office. They have a loved one who's on Medicaid, and so they're very cognizant of the resource limits, and they go, hey, we just got it was backdated Social Security in the amount of $11,000. Like, this is going to, this is going to push the family member off of benefits. Set up an ABLE account, plug it in there. We've got a source now where we can shield some of these assets, and we can make sure that there's a little bit more of a buffer there and a little bit more flexibility as far as if somebody's working or if they somehow come into some funds that would push them over that allowable amount.
We just got another question in here.
All right.
I will read it off. Hopefully I'm not cutting you off too much.
No.
Yeah, this has been super helpful. The other question is, when Medicaid establishes a state recovery from trust makers after they pass away, how does that affect wills and special needs trusts?
So, estate recovery. So, the beauty of estate recovery is that it does not apply to third-party special needs trusts. So, really, now I always tell people, if you die with, classic example would be if an elderly individual, let's say a widow, for example, they need long-term care. They don't have the assets to pay for it, and they they go on Medicaid, and Medicaid, there's $150,000 paid out on this individual's behalf. Then what Medicaid does is they reserve the right to file a lien against, basically against the estate, against the house, whatever. But that's because, but that's only really when somebody dies with assets in their name, and that, and Medicaid has kind of the ability to claw back, if you will. So if mom and dad set up a third-party special needs trust and they leave $500,000 in that to a disabled individual, Medicaid has no avenue to get that money. They have no avenue, because the reason is that they only get their access if it's first party assets, if it's assets in the name of the special needs individual. If kind of the way that the legal system looks at it is that, well, if mom and dad establish this trust and they go through all the work to provide for a disabled individual, and they check all the boxes as far as, Medicaid special needs trust, then they have then it's mom and dad's wishes, it's mom and dad's money going into that fund for the individuals, and therefore Medicaid does not have the ability or the authority to go after that money for services that were paid on behalf of the disabled individual.
Yeah, thank you. That makes sense. Cool. Well, yeah, like I said, this has been super helpful. Any other questions, comments? Feel free to throw them in the chat.
I was going to say, Brian, if I would, if the person who had the question about burial plans is here, I would love to I would love to kind of hear what their question is. And I just saw somebody put a question as far as needing resources in Colorado Springs. So what I'm going to do is I'm putting my email address in the chat here. So if anybody, I did just set my out of office before I hopped on here, but if you want to send me an email and just let me know how I can help, that's kind of my bat line these days, and I'll be happy to answer any questions, or certainly at least steer you in the right direction and tell you who I think does a good job and would be a good resource for you guys.
Yeah, that's perfect. Appreciate it. I was going to say, I'll make sure I saw your contact information at the end of that presentation, which
Okay.
I'll also send, but I'll make sure to include your contact information in like the body of my email when
Perfect.
I send this out to everybody, just so they have it. Because yeah, it seems like you're a great resource. Burial plans, nothing, I can't think of anything specifically. I just know they come up a lot. And like people who have them, they're super beneficial. So I don't know if you can talk to like how that can be included in estate planning, special needs trust. But yeah, maybe a little general info.
Yeah. So burial plans. So that is a very, very Medicaid question there, because it really kind of goes down to Medicaid's whole thing is it's a means-based assistance program. And so where burial plans come in is I think they have kind of a cap for it, but basically it's a legitimate expense. Classic example would be somebody has $15,000 left. They're going to need to go on Medicaid, and they go, all right, well, I'm still over-resourced. How can I make the best use of this money to make life a little bit easier for my family members? That would be a great situation where I would just say, hey, you know what? If you don't have some sort of burial plan in place, I can tell you a lot of people can be shocked as far as how much they cost. And I think there's just a comfort element too of knowing that, in a difficult situation, mom or dad or whoever, they have everything lined up. As you really just need to pick up the phone, and it's already been paid for, everything's been handled. And so that has long been a completely legitimate expense for Medicaid purposes. So a good example of how that could apply to, I talked about if somebody has an unanticipated inheritance, how you could, potentially put that in an ABLE account if it's, below that 17,000. Another way to kind of get rid of that money so that you're not over resourced and kicked off of Medicaid would be you could utilize those funds to purchase a burial plan. And that's, again, that's going to benefit the individual. It's going to benefit the family. But that's a completely above board use of funds as far as Medicaid is concerned. And so it's just kind of, it's a long held planning tactic just to, again, try to, not unnecessarily depleting funds, but, more so just kind of giving more options for, all right, well, if we've got to get down to 2,000 or we've got to stay under this 2,000, what can we do that's that's above board for Medicaid? And so burial plans are, they're a great thing that oftentimes kind of go under the radar and people don't think about until it's too late. So special needs person. Okay. So I'm just looking at the last question that came into the chat. If a special needs person receives a life insurance policy, is there any difference between whole life and term? Not to my knowledge. Really, the only thing that I would say, whether it's whole life or term, is that's a great reason to get a special needs trust in place, because if you've got a whole or a term, life insurance policy that the payout's $100,000. If you have if you name the special needs individual as the beneficiary on that, and there's not a special needs trust set up, that $100,000 is going to immediately, boot them off of, it's going to over resource them. And so I regularly use life insurance policies to fund special needs trusts. I think that's a great way to do it. But so yeah, life insurance can be an excellent vehicle to, to provide money for the individual. But you just want to make sure that they're not listed as an individual beneficiary, because again, that would put them at risk of losing any benefits or not being able to qualify for future benefits. Excuse me. Just to pay Medicaid. So the follow up to that: does Medicaid require that whole life must be cashed in to pay Medicaid? Unfortunately, yes. So if somebody is trying to qualify for Medicaid, anything, it's kind of crazy. IRAs, whole life insurance. I mean, basically their approach to, what is considered an available resource if you're trying to qualify for Medicaid is anything that can be converted to cash value. So that's certainly if, I believe if the cash out policy, or if the cash out amount of the insurance policy is less than $2,000, they'll give you a pass. But if you had a whole life policy and, the cash value that you could just kind of walk away with is 50 grand, they're going to require that they're going to say you're over resourced. You need to cash that out and spend it down or put it elsewhere. Can you use money currently in an ABLE account to set up and pay fees associated with a special needs trust? You certainly can. That is a textbook use of those funds. And I've had basically anything. I actually gave a presentation with one of the guys who is kind of the head ABLE account administrator for the state, and he was telling me, he said, there's there are certain requirements they're supposed to meet. But he said, I have never heard of any ABLE account getting audited. So he goes, basically the crux of it is if you're using that ABLE account for anything that's associated with the special needs individual, it's kosher as far as they're concerned. Ballpark costs for creating a special needs trust. Typically, if I would say for a well-drafted special needs trust, I think typically you're going to be looking somewhere in the $2,500 to $3,500 range. our practice, we do flat fees for pretty much all of our estate planning, and then the only real deviation is just kind of the particulars of how complex is it, how much is involved. But I think most of the special needs attorneys that I deal with, I would think that'd be a pretty I could be pretty confident in that price as far as that range. If we know someone with special needs in another state, would you say that most of the guidance we receive today applies across the country, not just Colorado? I wish that, and it's so funny too, because Medicaid is a federal program. So you would think that there would be, and I'm getting a little lawyer pessimism here, but Florida, for example, Florida's Medicaid, my head about exploded when I was at a legal education conference, and there was a Medicaid specialist there who operates in Florida, and he was telling me that basically an individual doesn't even have to be a part-time resident in Florida to potentially qualify for Medicaid there. So as much as I would love to say, and as far as the numbers that I've discussed, so the $2,000 and kind of the utilization of the ABLE accounts, that all carries across the United States. Where you see the differences is going to be how they. So Colorado, for example, they're pretty aggressive about looking over any sort of transactions that have ever occurred with family members. I can tell you that is that's one of those things where each state and honestly even each county can be a little bit different as far as how exactly it's going to work. For Colorado, everything I've talked about is going to be it's going to be correct as far as Colorado goes. There are definitely some differing approaches, though, particularly when it comes to estate clawback. That's really where I see the biggest deviations among states. There are some states that they haven't done that in a long time. They don't care about it. But then Colorado, they were one of the more aggressive ones for the past 10 years. So ARC is now automatically enrolling employees in employer retirement accounts, which could cause many. Oh, well, Gail, that is a question that oh boy, I would truthfully, I would love to hear more. And honestly, if you wanted to shoot me an email, I know David, the director of Larimer County ARC. He's a friend and colleague of mine, and he's actually a former attorney. I would love to discuss that with him and kind of hear a little bit more, because that would seem a little bit counterintuitive to it's like, okay, I feel like that's coming from a good place, but may not be the correct execution. So I would be happy to discuss that further with you if you wanted to shoot me an email. So can you ask for S&T funds to be invested in ABLE? Absolutely. In fact, I put that in all of my special needs trust, that's something that is a completely above board use of the funds. So yeah, I think that's a great use of the funds. And if that's something that somebody says, hey, I would like them to be able to set up an ABLE account, then yeah, we regularly provide for that.
Awesome. Really, really good questions. Thankfully you're on here.
Kind of a flood there. I hope I didn't, you got one more. I have a similar concern for a job retirement account that was created. Yeah. And so I suppose as far as, as the way that I tend to look at, particularly at SSI and Medicaid is that Colorado has kind of long taken the approach of, and it really kind of irks me from the financial standpoint, because I don't appreciate the fact that if I have $100,000 in a retirement fund, that doesn't convert to $100,000 unless it's in a Roth. I mean, if I wanted to pull it all out tomorrow, I'm going to take a massive penalty. Nonetheless, Medicaid says you have $100,000 assets available. And so I think just kind of knowing that that is how they treat retirement accounts, and not to dive too far into the weeds here, but with something like that, what I would say and what I have had quite a bit of success with, if that is a concern, is the thing that allows us to do a tremendous amount of good Medicaid planning and really preserving assets for individuals while still allowing them to qualify for Medicaid is the conversion of assets to income. And so I think that I think if you are in a situation where you're concerned about that, yeah, I would say shoot me an email, because that's a very situation specific problem. But the good news is that kind of based on the particulars of it, there's almost always going to be options available. And I think it's just kind of walking through how do we make the best use out of these retirement funds, whatever their nature, while still making sure that that we are not losing the ability to have those benefits. 100K cap for ABLE still applicable? What are options should we ever surpass it? So the $100,000 cap, and I will go back to so yes. So as far as how the $100,000 cap for ABLE, that actually only excuse me, I was drinking a bubbly drink, of course, while I'm talking. Rookie mistake. But the 100K cap, it only applies to basically how it works is that if you exceed $100,000 in an ABLE account, SSI benefits will be minimum. Basically, they'll start penalizing the SSI amounts at that point. But there's not, as far as I understand, there's not actually a cap as far, for Medicaid purposes. There's not really a cap. It's just, that is one thing to keep in mind. I would certainly say, I think it's just good practice if that ABLE account is getting up towards that $100,000 amount. That's where I'd kind of start using. I'd start using that for really. Hey, if the end, if you wanted to use that to pay for groceries, the same way that roommates would do that. Or if again, I think that there's a lot of ways that parents, caregivers, etc. They can, being a parent myself, you're going to go out of pocket a lot. And so I think to the extent that you can utilize those ABLE funds, I think that is a great thing to do. And again, if you're buying groceries for the house with the ABLE account, obviously don't do it every week, but hey, I kind of look at it as you can really treat the individual as kind of a housemate. Like if you were sharing an apartment with 3 other people, well, everybody's kind of expected to contribute. And so I would say, yeah, I truthfully, I probably wouldn't. I would book a trip for themselves and the caregiver, go to Europe or something with some of those, do something nice for yourself. But yeah. So next question would be, so would it be best to have the S&T be beneficiary of retirement funds? Oh, that is a 4,000 level question. And the answer is yes. I love utilizing an S&T to be the beneficiary of retirement funds. Now, why, you may ask? The reason is that a disabled beneficiary who meets all the requirements, they are allowed to stretch out the retirement account proceeds over their life expectancy. Everybody else has to take it within 5 or 10 years. They have to have the entirety of it paid out. Not so if you have a special needs trust. Now, there are certain kind of there are some certain quirks as far as the so one downside with that is that if you name kind of going back to, it's the great thing about third party special needs trust is that you can designate, all right, if there's any money left over, we want it to go to, we want it to go to our other children, something like that. The one problem, if you're, putting a hunk of retirement account benefits, and you're utilizing that stretch out with an S&T beneficiary, is that any remaining amounts from those retirement accounts, they cannot go to anybody older than the disabled beneficiary. So kind of getting into the weeds there, but it's one of those things that it's great to know, and it's great to kind of discuss the particulars of that's truthfully, it's kind of my litmus test when I'm dealing with financial advisors, is if they have an understanding of those kind of things. Because again, I think it's not so much oh, well, how much money do we have or anything like this? It's more so, how can we make the best, most efficient use of the family's assets, and how are we going to put everybody in the best position where, again, we're maximizing what we have. But yeah, that was it. So it's the Secure Act. If you want to bore yourself to tears, read up on the Secure Act, because that kind of changed the landscape for good estate planners and how they treat the retirement funds. But one of the nice things about the changes is that they still allow S&T beneficiaries to get that continued tax-free buildup and get a little bit more get a little bit more flexibility. So.
Awesome. Yeah, again, great questions. This has been super helpful. Anything else? Questions, comments before we head out? Really appreciate it. Well, like I said, this has been super helpful.
Good. Well, no, I thank you all for joining me and for peppering me with good questions like that. It keeps me sharp. So I appreciate you all being engaged, and I would certainly say if you guys have any questions, whether it's personal or just needing resources, I can certainly do my best to point you in the right direction, and I'm happy to help however I can.
Yeah, much appreciated. I'll make sure to get your presentation, your contact information out to everyone. Renee, are you saying, do we have one more question? You may not be off the hook yet.
An S&T and a durable trust work together to protect family assets. Yes, they can. And truthfully, I think that a lot of times the best kind of holistic planning is really going to involve some overlap between the two. And so, kind of a common example of typical estate plans that I will set up is number one, we need to make sure establishing the special needs trust is one component, but we also need to make sure that the assets are getting mom and dad's assets are getting where they need to go. And so I really love kind of piggybacking off of a family revocable living trust that we set up for mom and dad that they're in control of for as long as they're alive, and then basically just like within the trust, for example, we can say, okay, Jennifer's portion is going to, rather than it just going outright or anything, it's going to go into the Jennifer Johnson Special Needs Trust that we established at the same time as, mom and dad's trust. And so, yeah, I think, and that is, I think that's kind of where I earn my keep, is truthfully is just kind of understanding how the different pieces have to work together. But I think that the special needs trust, it's a hugely important component, but there's kind of a level of engineering to it that really kind of looking at it from that family sphere and saying, okay, how are we going to plan for the caregivers, for the beneficiary, for the other family members? That's where we can really be confident that we've kind of covered all the bases and that we have everything set up in the most efficient manner possible. So yeah, they absolutely can be used in tandem to protect assets. And thank you, Heather, for the kind words.
She summed it up well. Yeah, no, I agree. I think making it, yeah, just making it, I don't want to say dumbed down, but like you said, some of this can be Latin. So you did a really good job kind of explaining it.
Well, I appreciate that, because as many of these as I've done, I swear to God, when I say that I'll walk out of here and my wife will go, "How'd it go?" And I'll go, I think it went okay, but it's like I kind of start rambling at a certain point and it gets pretty intense. So I'm glad you guys found it helpful. And yeah, again, if there's any if you're like me, and you think of your best question as soon as you've logged off or walked away, please feel free to reach out via email. And yeah, I would be happy to I'd be happy to do another one of these if Brian and Kathy would want me back. Again, the special needs community, I think I'm always happy to donate my time to. I mean, I have just had it's been a privilege working with groups like yours who are doing wonderful work. And so I would be more than happy to do a part two if you guys would want that. We could certainly again, I'm not going to assume that Brian and Kathy would want me back, but yes, I would be more than willing to.
No, yeah, I think we have some other kind of general monthly meetings, things like that too. I think a lot of us would benefit from it. So definitely keep your contact information. Like I said, I heard really good things from other people in the industry, the field. So yeah, I think a part two could definitely happen. Also your contact information, just giving that to people working with you directly, I think is great as well.
Sure. All right. Well, thanks again, everyone. I appreciate all the great questions, and do not hesitate if there's anything else I can answer for you. Okay.